All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Judge Murdoch, good afternoon, everyone. I now turn to counsel for the defense. So, counsel, Mr. Hassan, you have 45 minutes for your opening statements. Microphone, please.
Thank you, Madam President. Thank you to the esteemed judges. I am aware that this time is not consecrated for the objective arguing about the case. However, I would like to say that we will reply to the Office of the Prosecutor and the LRV in the coming days. However, unfortunately, I have to say that the charges against Mr. Al-Hishri were adapted and changed according to the reality, and this is what we will prove to the court, because the Mitiga prison is affiliated to the Libyan prosecution and not to the SDF, and it's affiliated also to the Libyan Ministry of Justice. And the Rada is a governmental entity and not an armed group. It was established based on governmental sovereign decisions issued by the highest authorities of the state. However, in this session, we will talk about what we are supposed to talk about. Your Honors, since this case is the first case in the Libya situation before the ICC where the suspect is present and in which the jurisdiction, admissibility, and the merits are being discussed, so the defense has to present to the honorable judges the full picture of the situation in Libya following the issuance of the Security Council Resolution 1970 of 2011. This resolution was issued on the 26th of February 2011 by the UN Security Council, referring the situation in Libya to the ICC. And here we are today, 15 years later, before the ICC discussing this resolution. The mandate of the Office of the Prosecutor started in 2011 based on this resolution. This happened because of serious and systematic violations committed by the former Libyan regime, the regime of President Gaddafi, against human rights directed against civilians in Libya, including the use of violence and force against them. In addition to the violations of the rights of Libyan civilians, as stated in the text of the resolution and the subsequent resolution. And up until today, none of those who were responsible for these crimes from 2011 and 2013 and 14 have appeared before the court. The defense submits that Resolution 1970 has passed through 3 phases before the OTP since 2011. The first phase, the first attempt at prosecution by the OTP was through the issuance of 4 warrants of arrest against Muammar al-Gaddafi and his inner circle on charges of committing crimes against humanity. However, these decisions were not implemented and they were not executed at all. The OTP did not request any other, the issuance of any other arrest warrants for this phase. Since 2014 at least, the situation in Libya on the political and military level drastically changed, and Libya descended into a complex. So Libya descended into a complex conflict involving multiple means and objectives, and Libya was divided into East and West, and there was wide-scale violence, where Libya also witnessed the spread of armed militias and jihadist groups. And there were also internal struggles for power and change in political allegiances and external international influences. However, the OTP continued its investigations, and this time it focused on alleged war crimes perpetrated by several armed groups. As a result, a series of warrants of arrest were issued, and these were 9 orders for incidents that happened between 2014 and 2023. This phase did not lead to any prosecution for any of the suspects. However, in 2022, 10 years later, the OTP moved to another strategy focusing on crimes that happened in a specific geographical scope, and the investigations were constricted here. And here I would like to quote, as was said, in Tripoli and its surroundings. So they forgot about the entirety of Libya, and they say that, or the procedures against Mr. al-Hishri are phase 3 of Resolution 1970. And now, a decade and a half later, the OTP is trying to implement this jurisdiction that was given to them 15 years later. However, the defense see that this attempt does not go in line with the meaning of Resolution 1970, and it cannot be accepted that the Resolution 1970 applies to the case of Khalid al-Hishri. So I will go back now to phase 1. In February 2011, protests broke out in Libya as part of the so-called Arab Spring, which covered a large part of the Arab region. And according to Human Rights Watch, on 18 February, the official Libyan regime back then responded to those protests with severe force. And its security forces, the security forces affiliated to the Gaddafi regime, killed 84 persons in 3 days. And according to the same organization, this number rose significantly in the following days. However, these protests quickly turned into armed confrontations between the regime forces and the opposition fighters, who became a party with supporters and institutions both inside and outside the country. And Amnesty International issued a report saying the following, and I will quote this report. After most of eastern Libya and parts of the west, including Libya's third largest city, Misrata, fell to the opposition, al-Gaddafi forces unleashed a brutal military campaign in an attempt to regain control. They fired indiscriminate rockets, mortars, and artillery shells. And that is as well as cluster bombs into residential neighborhoods in opposition-controlled areas. Such attacks were particularly widespread in Misrata, but also took place in and around the Ajdabiya and Nafusa mountain. As projectiles rained down, civilians had nowhere to go. Victims included children and elderly Libyans and migrant workers. Many of them died in their homes or while trying to flee. 6 days after this report, or on the 26th of February 2011, this decision or resolution was issued. Slide number 5. The Security Council, expressing grave concern at the situation in the Libyan Arab Jamahiriya and condemning the violent and use of force against civilians. I'm talking about the text of the resolution here. Deploring the gross and systematic violations of human rights, including the repression of peaceful demonstrators, expressing deep concern at the death of civilians, and rejecting unequivocally the incitement to hostility and violence against the Libyan population made from the highest level of the Libyan government, considering that the widespread and systematic attacks currently taking place in the Libyan Arab Jamahiriya against the civilian population may amount to crimes against humanity, recalling the Libyan authorities' responsibility to protect its population, stressing the need to hold to account those responsible for attacks, including by forces under their control on civilians, acting under Chapter 7 of the Charter of the United Nations and taking measures under its Article 41. So this is the text, or these are the reasons that pushed the Security Council to refer the Libya situation to the court through its resolution. So these are set out clearly and accurately. So the resolution took place because of these reasons. The Security Council decides to refer the situation to the ICC. So the Security Council decides to refer the situation in the Libyan Arab Jamahiriya since 15 February 2011 to the prosecutor of the International Criminal Court. Decides that the Libyan authorities shall cooperate fully and provide any necessary assistance to the court and the prosecutor pursuing to this resolution, and while recognizing that states non-party to the Rome Statute have no obligation under the statute, and urges all states and concerned regional and other international organizations to cooperate fully with the court and the prosecutor. Madam President, esteemed judges, this is the text of the resolution. And then the prosecutor of the court received the case and started the investigation. And on the 16th of May 2011, or less than 3 months later, so it's the same month that we are in now, the OTP requested issuance of arrest warrants against Muammar Gaddafi, his son, Saif al-Islam Gaddafi, and the head of the Libyan intelligence, Abdullah al-Sanusi, on 2 counts of crimes against humanity. And these are murder and persecution, allegedly committed during the period from 15 February to 28 February 2011. And the court issued the arrest warrants on the 27th of June 2011. Slide 6. During the course of the investigation conducted by the OTP, the Security Council issued a second resolution on Libya, and that's Resolution 1973 of 2011, authorizing member states to take all necessary measures, notwithstanding paragraph 9 of Resolution 1917, to protect civilians and civilian populated areas and civilians under threat of attack in the Libyan Arab Jamahiriya, and establishing a no-fly zone above Libya. This was followed by military operations over Libyan territory carried out by the NATO. 18 states participated in the military operations in Libya. 14 of them are in the NATO and 4 partner countries. 15 countries participated in the air operations, and 8 NATO countries dropped munitions. In a report of Human Rights Watch about these military operations, these reports say that at least 72 Libyan civilians, one-third of whom are children, have died. So this report was issued and entitled An Unacknowledged Death. And I quote this report. At least 72 civilians, as you can see on the screen, one-third of them children, were killed as a result of air raids conducted by the NATO. One-third of them are children, so one-third of them are children. This number is much lower than the reality, but I will stick to the text. Human Rights Watch also provided details on the victims in 8 sites and shed light that most countries that contributed to the bombing campaign are state parties to the Rome Statute. However, when the prosecutor asked the NATO Secretary General Anders Rasmussen, the latter said, "We have no confirmed civilian casualties caused by the NATO campaign." However, a while later, the spokesperson of NATO stated that it appears that innocent civilians may have been killed or injured despite all care and cautious that was taken. So this is quoted from Human Rights Watch. However, Madam President, there's a very important testimony of a Libyan national on slide 9. So this person, called Mustafa Naji al-Murabit, said the following: "My family has been destroyed. I lost my 2 little boys and my wife, Ibtisam, who was also my best friend. It is really difficult to go on now in this life, to get up every day and face life. So I tell myself that I must find the strength for my only child that I have left in this world. He cannot forget the horror that happened to him on that day when the bodies of his mother and little brothers were blown to bits. How can I help him to overcome this trauma? I myself can't cope with this new situation, and I cannot find anyone to turn to. Nobody from the NATO contacted me, neither from the authorities has gotten in touch to ask what happened or to offer an explanation of what happened or to even say one word of apology. We are living a miserable life. We have nothing left. Our home and everything in it were destroyed." End of quotation. Now I will talk about the stance of the OTP when it comes to the NATO aggression against civilians. And this was mentioned only in 4 reports. In the first report, the OTP did not acknowledge directly in its report to the UN Security Council that the air raids of the NATO has led to the killing of any civilians. However, in the second report, submitted to the Security Council as well, the OTP said the following, I quote, "We have visited the NATO office and the NATO, we will wait for the NATO's reply based on the investigation." So we are talking about paragraph 57 of the report. So here we can clearly conclude that the prosecutor of the ICC had an assessment that attacks against Libyan civilians by certain NATO forces were a matter requiring investigation. Slide 10. In the third report, the Office of the Prosecutor confirmed that its mandate included alleged crimes committed by all parties. It also stated in the third report that it was assessing the existence of genuine national proceedings and that the states participating in the military operation bore the responsibility of the investigation, whether their forces were involved through negligence or otherwise in any criminal activity. The Office of the Prosecutor also stated that it will monitor these proceedings in order to determine whether it should conduct its own investigations. So, there are those who acknowledge that crimes were perpetrated and they need to be investigated, but they will wait for the national procedures to see whether to investigate or not. So this acknowledgement and the national proceedings about incidents that happened in Libya were only given by the OTP to first world countries. However, in the fifth report issued in May 2013, the OTP stated once again that it remains in contact with the NATO and the Libyan authorities, and this time it added that it was in contact with the Libyan authorities concerning investigations related to possibility of incidental loss of life. It also confirmed that it had no information allowing it to conclude that the air raids of the NATO have led to loss of lives, and that they also targeted the civilians and had an excessive or exceeded their military targets only. So in the fifth report, we move to page 3. Here, the Office of the Prosecutor acknowledges the national proceedings that happened in the first world country and now moved jurisdiction to first world countries about the incidents that happened outside of these countries' territories. However, this time it added Libya, considering that Libya is able to do the same and make its own national proceedings. So this is the text of the report submitted by the prosecutor. However, after this fifth report, the case disappeared completely from all the reports of the prosecutor and they were never mentioned anymore. So we are talking here about the incidents of 2013. So there was no clear, or 2011, and then there was no clear report whether Libya or any country or NATO country has conducted any real investigation about Libyan casualties. So we cannot find any realistic explanation for this, and we cannot find any explanation why the OTP did not take any measures. And then the result, Your Honors, is a clear gap in accountability by the Office of Prosecutor for the crimes and the victims that fell as a result of the events of 2011. However, the Office of the Prosecutor that said that it will monitor local proceedings in all countries, whether first world countries or Libya, did not explain at all afterwards how this monitoring happened or why civilian casualties from NATO campaign did not lead to any further investigations by the OTP. The question here, are there Libyan victims who are of a first category, like considered as first category by the OTP, that are given more importance, and then other civilian victims that are in a second class that are ignored? The Libyans are wondering, Your Honors, is this court only working for the population of the south of the Mediterranean, or was there a shortcoming somewhere in the investigations? So there are some explanations that say that the Security Council resolution is being dealt with in a way to apply it only to the civilians of the Middle East only. Slide 11. The conclusion from the investigation of the OTP under Resolution 1970 was that among the warrants of arrest that were issued following the events of 2011, so none of these led to any prosecution, and the case against Muammar al-Gaddafi was terminated on the 22nd of November 2011 following his death. And then the case against Abdullah Sanusi was declared inadmissible, referring to domestic proceedings. And then investigation started in the incidents that happened in 2011 and 2013, and certainly nothing changed. And here, Madam President, I have an important remark, and that is the judges in this court, in the case of Mr. Sanusi, ICC 01/11-01/11085, considered the Libyan judiciary to have the competence and capacity to try crimes that the Office of Prosecutor had classified as international crimes. Despite that, the Office of the Prosecutor only clearly stated in 2022 that its investigations into the crimes of 2011 had been completed, indicating that it does not intend to pursue new cases related to that period. Report number 23, paragraph 77. The investigation, or the OTP closed the investigations of the incidents of 2011. And in general, the investigation of the OTP based on Resolution 1970 had limited result with non-execution of any arrest warrants, whether through the death of the suspects or admissibility obstacles and selective accountability. Yet the result remains the same, saying that the events of 2011 did not result in any trial and left major alleged crimes, including incidents of civilian casualties caused by NATO also, without any clear outcome of public accountability, neither on the international or domestic level, neither in Libya nor in other states. Can we say that there is an interpretation that there's a ignorance of the meaning of Resolution 1970 of 2011?
المرحلة الثانية من تحقيقات، ويمكن وصف هذه المرحلة فيما بعد.
This phase can be described as the second phase can be described as the post-former regime phase, in which the Libyan regime became politically divided between competing administrations. Violence escalated and the country became geographically divided between centers of power, each supported by armed groups of foreign backers. In the east, power was concentrated in the House of Representatives and the forces of Field Marshal Khalifa Haftar, whose Libyan National Army became the dominant military actor in the eastern and southern Libya. In the west, power was concentrated in the hands of the United Nations-backed government of National Accord based in Tripoli. Armed groups proliferated far beyond the division that had prevailed under the former regime between revolutionary and anti-revolutionary forces. Many groups arose from local, tribal, ideological, and sectarian conflicts. Their loyalties often changed with new alliances and groups forming around local interests, political opportunities, or opposition to particular adversary. Here, based on these new developments, the office of the prosecutor changed course since 2011 to a new course, a new field of investigation. Slide 13. I will briefly address the competing political administrations and the proliferation of armed groups present in Libya at that time. According to media reports and reports of non-governmental organizations and human rights organizations, non-governmental and sometimes governmental, and also the United Nations mission to Libya, about the violence, the serious violence that was arbitrated by military actors that carried out serious attacks that may fall within the jurisdiction of the court. For example, in 2013, an attack near Al Jala Hospital in Benghazi resulted in the killing of at least 12 people. In 2015, groups affiliated with the Islamic State in Iraq and the Levant, ISIS, Daesh, were responsible for the beheading of 21 Coptic Christians and for the killing of 30 Ethiopian Christians. In 2016, ISIS, which controlled Sirte at that time, killed more than 70 people in response to an attempted rebellion by forces opposed to it. In 2017, a military force attacked the Bark al-Shati air base controlled by the Libyan National Army, resulting in the killing of approximately 140 people. In 2018, armed groups led attacks against oil infrastructure in Libya. In 2019, an airstrike on the Tajura migrant detention center resulted in the killing of 53 people and the injury of more than 130 others. All armed conflict incidents that remain uninvestigated. Now slide 14. Prior to that, in an incident years before that, Ms. Fatou Bensouda, the former prosecutor of the ICC, on November 5, 2015, in her statement before the Security Council, she said that all parties of the conflict commit crime, including crimes that fall within the jurisdiction of the ICC. That was from the statement of Ms. Fatou Bensouda, paragraphs 39 and 40. At this phase, the Office of the Prosecutor continued to investigate the potential crimes which it believed fell within the jurisdiction of the ICC in relation to the post-Gaddafi regime period. But it focused on specific groups, and 9 arrest warrants were issued. They are publicly available in the website of the ICC. None of these arrest warrants has been executed, and no trial has taken place to date in respect to this phase. So here we see the first phase that go without trials and the second phase as well. Here, the prosecutor resorted to entering into the new phase, the third phase. The third phase of the investigations of the OTP is wholly unrelated to Resolution 1970 of 2011, concerning which was the foundation of the jurisdiction of the ICC. They started investigating entities, internal entities and activities that were newly created and that did not exist at the time of the United Nations resolution and when it was issued, nor that serve the objectives or the reasons of its issuance. Here, I can say that there is an overreach of the Office of the Prosecutor in its understanding of its limits and requirements of Resolution 1970 of 2011, and it in burdening it with what it cannot bear in concerning the situation in Libya against any party. We're talking about the third phase.
وتأكيدا لذلك
Therefore, Madam President, I would like to quote what the OTP stated in its report number 28 in November 30th, 2024. I quote, the OTP says verbatim, at a minimum, the office also seeks to commence at least one trial before the court in relation to the situation in Libya before the end of 2025, followed by several trials during the judicial phase. This depends on the arrest and surrender of suspects, which is an obligation under Council Resolution number 1970, and which the office has intensified its efforts in various situations during the reporting period. The office also confirms that after 2025, it will continue to support the Libyan authorities and other national authorities in achieving accountability. So they are transferring the jurisdiction to the national jurisdiction in accordance to the two-track approach set out in its policy on complementarity and cooperation. Page 4, paragraph 2 of the report. So here, the OTP is admitting that the Libyan jurisdiction has jurisdiction. Justice, Madam President, Your Honors, is a human necessity driven by moral motives and objective justifications for the stability of societies. It cannot be a schedule of achievement that disregards the objective circumstances of societies. Justice is deeper and more profound than this, especially international justice. The crimes attributed to Mr. al-Hishri are not connected at all to the Libyan crisis situation that triggered the court's jurisdiction under Resolution 1970. The resolution is limited to events of armed violence and serious violations of human rights connected temporarily to the former regime in Libya, and the armed violence between the Gaddafi regime and its opponents, as well as the external forces to which the subsequent United Nations Resolution 1973 drew attention. Even if we accept the allegations of the Office of the Prosecutor concerning Mr. al-Hishri and the group to which he is alleged to belong, we find that the crimes attributed to Mr. al-Hishri, which he denies in the first appearance, relate to the governmental entity established after the fall of the former Libyan regime. Its objectives had no connection with the former regime or with reaching power in any form. The specific objectives pursued by that entity was to fight terrorism, drugs, and other crimes. These objectives and the crimes alleged to have been committed were not related to the former regime, to the Resolution 1973 or 70, which founded the base for the jurisdiction of the ICC. For this reason, Your Honors, the Office of the Prosecutor resorted to obtaining a new or supplementary basis to support its position, because the prosecutor was in a difficulty in light of Resolution 1970, because it was no longer sufficient to establish the jurisdiction of the International Criminal Court in respect of the situation in Libya. It therefore resorted to that agreement dated 14 May 2025 with Mr. Abdul Hamid Beiba in order to escape its predicament and find new basis for the court's jurisdiction. It accepted that agreement from a prime minister whose legal mandate has expired, who does not control all of Libya. The whole of East is outside his control, and its South is outside of his control. He is not even able to visit the entire territory of the Libyan state. And accepting this document in violation of the Libyan constitution. The effects of this document are supposed to apply to all Libyan territory, all the Libyan citizens, in an attempt to create a legal position that would serve as basis for jurisdiction. I would say this more clearly, Madam President. Had the Office of the Prosecutor been confident of the court's jurisdiction over this case, it would not have resorted to relying to the agreement of 14 May 2025. And briefly, I will also stick to the time allocated. We have affirmed on April 30th in our brief that we challenged the jurisdiction of this court, and yesterday we also filed the letter after the request for assistance that we filed. We filed this submission to your honors yesterday. Nevertheless, slide 12 to be private only, your honors. When such mandate is issued, we notice it's undated with no filing number, just personal letter. It's supposed to be by a head of state that issue or send its documents through due process. We cannot identify the writer or the author of this person until we requested to reveal the document or the author of this document. And since it's a private document, I will stick to this confidentiality. According to this letter, an agreement, which is also confidential, was reached, as we refer to it in our submission. I will not repeat, but even this is unsigned. According to the document that was presented to defense, we have not seen the signatories. We requested it officially, but we only received an unsigned document, an undated one. In response for all of this, slide 17, please. Madam President, I think things are clear now. Mr. Abdelhamid Dbeiba, the Prime Minister who was voted out of confidence according to the the House of Representatives of Libya. As we see, the first article, it says, confidence is withdrawn from the government of national unity headed by Abdelhamid Dbeiba, and it shall be considered a caretaker government. The job of this government is to facilitate the situation and not to enter into agreements. This decision is effective immediately and is published in the official newspapers. However, this agreement, Madam President, flies in the face of the Libyan constitution, which took two phases. The first one is declaration and then amendments. The first one, the Libyan constitution was issued during the in Article 17. The Transitional National Council is the highest authority in the Libyan state and exercises the supreme sovereignty functions, including legislation and setting the state's general policy. It is the sole legitimate representative of the Libyan people, deriving its legitimacy from the 17th of February revolution. It is entrusted with ensuring national unity and the territorial integrity, embodying and spreading values and morals, the safety of citizens and residents, ratifying international treaties, and establishing the foundations of constitutional democratic civil state. Therefore, any agreement not ratified by this council is null. Slide 19. This constitutional declaration dated February 23rd, 2023, and it presented a new rule in which it limited the mandate of the president. And when we say the president, it's the president, Mr. Al-Menefi, the president of the Libyan Presidential Council. The president of the state has the following mandate: 1, appointing and dismissing the prime minister, approving the formation of government, conducting ministerial reshuffles in Article 15, The President of the state is the supreme commander of the armed forces. He shall declare war and conclude peace in accordance to the provisions of this instrument. But what matters here, what's relevant, is Article 16 of this amendment. The President of the state is the representative of the state in its external relations and has the power to conclude treaties and agreements in accordance with this amendment. Therefore, entering into any international agreement is the mandate of the President. And in the letter we filed yesterday, the situation was presented clearly and unequivocally about this agreement entered with the ICC. In this amendment, the Constitution was stated clearly who has the right to enter into any agreements. Therefore, the President is the President of the state alone is the representative of the Libyan state in all its foreign relations, and the person who has the power to sign treaties is the President of the state alone without the Prime Minister. Accordingly, the authorization issued by Mr. Abdulhamid Dbeiba to the ambassador of the Libyan state to the Kingdom of the Netherlands is void, and the signature of the ambassador of the Libyan state to the Kingdom of the Netherlands on the declaration accepting the jurisdiction of the ICC is also void. Therefore, I would like to attract your attention, Your Honors, to the following amendments, which was in the documents of the United Nations. It was quoted twice. The latest amendment of the Libyan constitution was quoted twice and was accepted. Mr. Menefee was received in the international or general meeting of the United Nations as the sole representative of the Libyan state. We have submitted both articles and letters in our filings. Madam President, Your Honors, there is also another letter by the Council of the Presidential Council that clarifies some items, some of which might be confidential. But what I would like to say that every act starts after immediately the following day after the amendment takes effect, and the number on top of the letter designates is for the local entity and not relevant to the House of Representatives.
I'm sorry to tell you that you have exhausted your 45 minutes. Did you get the translation?
نعم استمعت الترجمة.
Yes, Your Honor. Yes, Your Honor.
So you have to conclude very soon and be very brief, please.
هل يمكن
Your Honor, may I request an indulgence of 10 minutes? I request 10 minutes, Your Honor.
After having consulted with colleagues, you have 10 additional minutes, Counsel.
أشكر كرم الدائرة.
I thank Your Honor for this accommodation.
سأكون سريعا جدا.
I will be very brief. I refer most of my submissions to the file submitted on April 30th, 2026, and its continuum filed yesterday.
إلى سلوك
I would like to focus on the behavior of Mr. Dbeiba, the Prime Minister. Slide 21. he is always hiding behind others. Instead of instead of coming here in person signing this agreement, he issued an authorization, and this is precisely what he did before with Ms. Nagla Mangoush, the Minister of Foreign Affairs. He asked her to negotiate and enter negotiations with the state of Israel, which is strictly rejected by the state of Libya. And when this became known, and protests and people took to the street, he stated, I don't know anything about this authorization and I cancel it. And Ms. Najla Mangoush disappeared and never appeared after this till this day. Madam President, finally, yesterday, the Supreme Administrative Entity has made a clear and final decision regarding the letter of the Prime Minister, and the Prime has been filed to your honors, to the chambers. I conclude my submissions here. I would like to say that the Libyan constitution is strict about a mandate of representation and the right to enter into agreements and treaties, and it is not the Prime Minister at any case. This is unequivocal, and there is no doubt about the amendment of the constitution in 2023. According to this amendment, entering in and signing agreements and treaties is the sole right to the President of the Presidential Council, whose stance is very clear and has been declared. This unpublished agreement, which is not ratified by the House of Representatives, is void. The legal power of this document and the acts of Mr. Dibeba do not reflect the stance of the Libyan state and doesn't compel the Libyan state to anything. It is a document without any legal implication to the state of Libya or the citizens or residents, and it is not sound for a foundation for any consequences before the ICC. Finally, Your Honors, can the ICC, which is the highest criminal court in the International Criminal Court, can it rely on violation of the law? It will, if it will have also infringed the individual collective rights of persons and groups and will have violated the United Nations and those that were issued by the General Assembly or Security Council. I am confident that the court will respect the the Libyan people and its institutions, and I salute the historic heritage of Libya. I conclude my submissions. Thank you, Your Honors.
George Motok. Thank you very much, Counsel Hassan. We can now move on to the arguments on the merits. We will, over the next 2 days, listen to the oral submissions of the prosecution, the legal representatives of victims, and lastly, the defense for Mr. El Hishri in that order. Madam Deputy Prosecutor, or her representative, you and your team have the floor. As organized, the hearing will be 1.5 hours. Please do not hesitate to signal us whenever you feel it is time to take a break of 30 minutes, when it's convenient to you.
Thank you, Madam President. My submissions today will be approximately 45 minutes, and with Your Honor's indulgence, I request to be able to continue until the end of this session, which would make it 3:15. Madam President, Your Honors, the prosecution's presentation will be divided into 4 parts. I'll begin with a brief overview of the charges, the evidence, the suspect and his role, and the evolution of the Special Deterrence Force. Then I'll address proof of the contextual elements of crimes against humanity and war crimes. My colleague, Mr. van der Werf, will thereafter present the evidence of counts 1 to 12 on the crimes of torture, cruel treatment, imprisonment, outrages upon personal dignity, other inhumane acts, rape, sexual violence, murder, and attempted murder. Next, Ms. Looping will present the evidence of counts 13 to 17 on the crimes of enlistment and enslavement and persecution. To close the prosecution's presentation, Mr. Murad will present evidence of Khaled al-Hishri's criminal responsibility for the charged crimes. Your Honors, we've distributed a list, a table, with quotes and citations, including registration numbers in sequential order, to avoid having to refer to the registration numbers during our presentation. We will highlight key facts in evidence during our presentations, keeping references to witness evidence limited in order to maintain public session. We refer Your Honors to the evidence set out in the pre-confirmation brief and our list of evidence. Our presentation will be accompanied by visual aids, and we will signal when a visual aid needs to be displayed confidentially. Turning now, Your Honors, to the charges and the evidence. Khaled al-Hishri is charged with a total of 17 counts, 6 counts of war crimes and 11 counts of crimes against humanity for the imprisonment of thousands of civilians and protected persons without legal basis and without due process between 1 May 2014 and 30 June 2020. The charged crimes include the violent abuse that he and others inflicted on civilians: torture, rape, enslavement, persecution, sexual violence, cruel treatment, other inhumane acts, outrages upon personal dignity, murder, and attempted murder. As you will hear throughout our presentation, the conditions of detention and the serious and repeated abuses inflicted on all prisoners over many years fall outside the scope of any lawful prison system. For the purpose of the confirmation hearing, Your Honors, the prosecution is relying on the statements of 63 witnesses. These witnesses include 47 former Mitiga prison detainees, 2 relatives of former detainees, and 14 witnesses who are primarily relevant to the issue of jurisdiction and contextual elements of war crimes. The prosecution also relies on other materials, including decrees, laws, and other official documents, photographs, videos, and drawings of Mitiga prison, compound, and SDF RADA, contemporaneous reports by the United Nations and non-governmental organizations, press statements, and open source material, including social media and official websites. I will now turn to the suspect, Your Honors, and his role in the case. As my colleagues will set out in greater detail in the course of their presentations, the evidence shows that Khaled al-Hishri was a senior leader in SDF RADA based at the Mitiga prison, was in charge of the women's section of the prison, where women and children were detained in inhumane conditions and abused, and where he raped, tortured, and enslaved Libyan and non-Libyan women. That he exercised general, although not exclusive, authority in Mitiga prison, derived from his leadership position his family connections in SDF Rada, and his reputation and propensity for violence. He had authority over cell allocation for prisoners, the timing, duration, and methods by which prisoners were tortured, the release or continued detention of prisoners, including the authority to defy release orders by the Attorney General. Witnesses consistently describe Khaled al-Hishri as a powerful member of SDF Rada, who, with others, quote, controlled everything within the prison. Finally, and notably, Khaled al-Hishri personally and directly committed the crimes in each of the 17 counts. I will spend a moment, Your Honors, to describe where the crimes took place. Nearly 90% of Libya's roughly 7 million inhabitants are concentrated along the coast in the main cities of Tripoli, Misrata, and Benghazi. Southern Libya's vast desert region is inhabited by roughly 10% of the population. The charged crimes in this case occurred in Libya's capital and largest city, Tripoli, in the northwest of the country. Approximately 1 million people live in Tripoli. The officially recognized Government of National Unity, or GNU, is based there. The crimes allegedly took place principally at the Mitiga compound, located in the northeast of Tripoli, near the coast. The Mitiga compound, outlined in green on your screens, covers a sizable area and includes the Mitiga prison complex and the Mitiga International Airport. SDF Rada has its headquarters in the western part of the compound since 2011, outlined in your screens in blue. According to witnesses, Mitiga prison was established in 2012 and was gradually expanded by SDF Rada during the period of the charges. The Mitiga prison includes a main prison building with outer and inner yards, and an area known as the Naklia, where detainees were regularly brought for torture and interrogation. Mr. van der Werf will further describe these and other locations of relevance when detailing the evidence of the commission of the charged crimes. Turning now, Your Honors, to the main prison. The main Mitiga prison building is divided into sections. The guards and prison leadership had offices just meters away from the detention sections. Mitiga prison also contained a full surveillance system. Victims were watched at all times. First, by the hierarchies within the prison, starting with the capos, who were prisoners assigned as the heads of prison cells and sections. Second, by the guards and the shift commanders, conducting regular patrols along the corridors or along the gridded roofs which directly overlooked detention areas. And of course, by the Mitiga prison leadership, including Khaled al-Hishri himself. CCTV cameras were installed throughout the prison, in corridors, hallways, inner yards, and even in specific cells. Khaled al-Hishri and the other perpetrators at Mitiga prison monitored the surveillance footage from a CCTV room inside the prison building, also shown on your screens. As Your Honors will hear, Khaled al-Hishri's regular physical presence at the Mitiga prison, his orders and authority, his personal commission of the charged crimes, and the surveillance systems at Mitiga prison all establish that he was aware of and intended to commit the crimes for which he is charged. The Mitiga prison leadership used the prison as an instrument of coercion, intelligence extraction, punishment, intimidation, extortion, and domination of the civilian population in and around Tripoli. Within the prison, institutional violence against detainees was normalized, organized, and repeated between at least May 2014 and June 2020. I will now turn to the creation and evolution of SDF RADA since its inception through the period of the charges. I note by way of background that contemporaneous reporting on Libya's security sector has highlighted the emergence of hybrid security institutions after 2011 that blended existing formal state apparatus and informal non-state actors such as militias. Groups that controlled security sector institutions were able to exert political influence and gain control of economic assets such as salaries and equipment. The SDF RADA was one such group. According to witnesses and contemporaneous reports, in 2011, the SDF RADA originated as a group of local anti-Gaddafi forces from the Souk al-Juma neighborhood in East Tripoli, next to the Mitiga compound. Abdel Raouf Kara was at the head of this group, as he remains today. According to witnesses, Khaled al-Hishri and Osama Njim were part of Kara's force since the time of the liberation of Tripoli in 2011. Both men assumed important positions within the SDF RADA, based at Mitiga Prison and Compound. Osama Njim became the director of Mitiga Prison, while witnesses describe Khaled al-Hishri as the second in command under Kara. Witnesses state that prior to the revolution, Kara had been a blacksmith. Khaled al-Hishri had been a fisherman, and he made and sold alcohol. Osama Njim had been a collective taxi driver. We have no information that any of these three men had prior law enforcement training. By 2012, Abdel Raouf Kara and his men, including Khaled al-Hishri and Osama Njim, were integrated into the newly established Supreme Security Committee as a support brigade. Kara named his brigade the Special Deterrence Force. The group became commonly known simply as RADA, which is the Arabic word for deterrence. On its official website, SDF RADA confirms that it was formally established in 2012 as part of the support brigade in Tripoli. From 2012, SDF RADA's operational influence grew. Notably, in July 2014, the Tripoli International Airport was attacked and destroyed. 1 month later, in August 2014, the Mitiga Airport became the sole airport for Libya's capital city of Tripoli. Control over such a strategic facility reinforced Kara and SDF RADA's political, economic, and security influence. SDF RADA's power grew further in 2015 through its support of and affiliation with the Government of National Accord, or GNA, and of the Presidential Council, comprising the officially recognized government in Libya. In 2017, the evidence shows that SDF RADA had over 1,500 members. The United Nations Office of the High Commissioner for Human Rights, OHCHR, reported in 2018 that SDF RADA was aligned to the Presidency Council, received salaries, uniforms, and equipment from the state, but maintained its own command structure and operated within a significant level of autonomy. In May 2018, The Presidential Council attempted to rebrand SDF Rada as the Organized Crime and Terrorism Deterrence Agency, also known by the acronym DACOT. It was given wider remit, independent budget, and greater powers. Nothing, however, changed in terms of its leadership or membership. It continued to function as it always had, but with more power. Witnesses continued to refer to it as SDF Rada. Your Honors, in sum, the SDF Rada emerged from the revolution and rose to prominence through the resulting armed conflict and proxy wars. While SDF Rada was later given an official mandate with a new name and an independent budget, it retained the same leadership, membership, property, and significant assets. It was organized, structured, and had the means and resources to carry out its objectives. As such, at all material times, it remained able to operate independently in accordance with the wishes of its leadership. Madam President, Your Honors, I will now turn to the contextual elements. The contextual elements of crimes against humanity are established in this case because, first, there was an attack against the civilian population in and around Tripoli, including against persons in the custody or control of the Mitiga prison perpetrators. Second, the attack was widespread and systematic. Third, the attack was carried out pursuant to or in furtherance of an organizational policy. And fourth, Khaled al-Hishri knew of the attack and his conduct was linked to it. The evidence establishing the contextual elements of crimes against humanity are set out in our brief at paragraphs 6 to 23. I will now address each of these points in turn. In relation to proof of an attack, our case is that the SDF Rada, Mitiga prison leadership, and Mitiga perpetrators carried out a campaign of violence in and around Tripoli and against detained persons, principally at Mitiga prison, between the dates of May 2014 and June 2020. They targeted civilians who were perceived as undesirable, disloyal, oppositional, or who could be used to build and sustain the power and finances of the SDF Rada and its associates. Over a period of at least 6 years, thousands of civilians were arrested without lawful basis, transferred to Mitiga prison compound, imprisoned without due process or in unlawful conditions, subjected to repeated and severe acts of physical and psychological violence amounting to crimes under the Rome Statute. These civilians were imprisoned within a system designed to control, enslave, persecute, torture, degrade, and ultimately to break them. The campaign of violence is established through these repeated patterns and repeated criminality, committed within a detention regime that was organized and coordinated on a large scale. It was sustained and it was brutal. Imprisonment was the foundation upon which multiple further crimes were carried out. Crimes that included regular and in some cases continuous institutionalized forms of violence, as you will hear in detail during our upcoming presentation. Together, the commission of these crimes constitutes the attack. Your Honors, the attack must be made against a civilian population. The victims in this case were overwhelmingly civilian in and around Tripoli. They included women, children, and elderly persons. They were students, business persons, civil servants, engineers, technicians, medical professionals, journalists. They were Libyans and non-Libyans, including Black African migrants. They included people who were perceived to hold opposing beliefs, views, identities, affiliations to those of the SDF Rada. Irrespective of the reasons for which they were imprisoned, they were all subjected to the same criminal system of mistreatment. Established case law at the ICC, building upon case law from the ICTY, including in the trial judgments in Abdel Rahman, Ntaganda, and Al-Hassan, confirm that victims of crimes against humanity need not share the same nationality, ethnicity, religion, or similar distinguishing features. Crimes against humanity protect any civilian population as a collective. The population is defined functionally by the scale and systematicity of the attack, not by group homogeneity. Rather, the specific crime of persecution addresses the targeting of a particular group. The defining characteristics of the civilian population in this case are that they were located in and around Tripoli and were all subjected to the criminal system of abuse during their imprisonment, principally at Mitiga prison. Madam President, Your Honors, the attack was both widespread and systematic. The requirement that the attack be widespread speaks to scale in terms of numbers of victims, duration of conduct, and geographic scope. The prosecution has identified at least 945 victims in an annex to the pre-confirmation brief. However, this is a representative sample of a much larger number of persons who were targeted, arrested, and detained, principally at Mitiga prison. During the period of the charges, the true number of victims runs into the thousands. Witnesses and the United Nations report a steady increase in detainees at Mitiga each year. By 2021, a witness estimated there to be up to 5,140 people imprisoned at Mitiga. This figure alone establishes that the attack was widespread. The widespread nature of the attack is also established through the repeated arrest operations and sustained imprisonment over a long temporal period and throughout a large geographic area. Your Honors, the attack was also systematic. The requirement that the attack be systematic speaks to organization, pattern, and method. As Mr. van der Werf will detail, the arrests, detention, and abuse followed regular, identifiable patterns. No fewer than 47 detained victims in this case, many who never met each other and were detained at different times, describe strikingly similar experiences that amount to patterns of conduct, including in relation to their arrest procedures, the transportation they took to Mitiga prison, the intake routines they faced, the interrogation processes and where they took place, recurring methods of abuse, including torture and torture methods, forms of humiliation and other degrading treatment, and the similarity of insults used by Khaled al-Hishri and the Mitiga perpetrators. They also consistently identify the Mitiga prison perpetrators. This level of consistency is the hallmark of a system. It demonstrates coordination, structure, and means. It demonstrates that these crimes were neither random nor coincidental. Contemporaneous reporting of the United Nations Support Mission in Libya, also known as UNSAMIL, corroborates the evidence of these witnesses. In 2016, UNSAMIL described, and I quote, a pattern of severe torture and ill treatment, close quote, at Mitiga prison. In 2018, UNSAMIL reported on the systematic denial of due process rights, notably in the Mitiga detention facility, controlled by the Special Deterrence Force armed group. Your Honors, the attack was also carried out further to an organizational policy. Proof of an organization rests on its features, such as its hierarchy and its ways of functioning, that would allow it to conceive, adopt, and implement a policy to carry out a widespread or systematic attack against a civilian population, along with the resources, means, and capacity to actually carry it out. SDF RADA was structured and organized, as I briefly described earlier in my presentation and as set out in our brief. It operated Mitiga prisons since at least 2012. It had an established and effective hierarchy, and it was well-resourced with weapons, ammunition, uniforms, vehicles, means of communication, and surveillance. SDF RADA controlled territory in Tripoli, in particular, though not only, the Mitiga compound, with influence across the city. SDF RADA had the resources to sustain a full system of arrest, detention, and abuse during the 6-year temporal scope of the charges. Your Honors, this evidence shows that SDF RADA was an organization. I turn next to the policy element. The policy element is satisfied if the attack against a civilian population is coordinated rather than being spontaneous. It does not need to be written. A policy to attack a civilian population can be proven through consistent patterns of conduct with the means to continue. In this case, the number and frequency of attacks against civilians and the scale of the crimes committed establish that the attack was neither random nor isolated. It was carried out repeatedly for many years. The evidence demonstrates SDF RADA's coordinated actions in arresting, imprisoning, and abusing civilians. For the last element, Your Honors, the evidence establishes substantial grounds to believe that Khaled al-Hishri acted with knowledge of, and his conduct was related to, the widespread and systematic attack. As a member of the Mitiga prison leadership, Khaled al-Hishri operated within a detention system that functioned in the same way for years. He directed and observed the recurring patterns of arrest, arbitrary detention, and abuse. He exercised authority within the prison. He contributed daily to its functioning. Not only was he physically present during intake sessions and interrogations, he personally committed the charged crimes against the civilian population. The scale of the attack and flagrant abuse was clearly visible to him. Your Honors, I will now turn to the evidence in support of the elements of war crimes under Article 8 of the Rome Statute, as set out in paragraphs 24 to 44 of our brief. The evidence establishes substantial grounds to believe, first, that there was at least one non-international armed conflict in Libya throughout the charged period. Second, that the charged crimes, including torture, cruel treatment, outrages upon personal dignity, rape, sexual violence, and murder, were sufficiently linked to the armed conflict. And third, that Khaled al-Hishri was aware of the factual circumstances that established the existence of the armed conflict. Firstly, Your Honors, on the existence of a non-international armed conflict. At all times relevant to the charges, the crimes were committed in the context of and were associated with a non-international armed conflict in Libya. While its intensity fluctuated over time, there is no doubt that the hostilities encompassed complex and sustained military operations, far exceeding mere temporary unrest. ICC jurisprudence in the Ongwen case establishes that the armed conflict need not be continuous or uninterrupted. The Chamber need only find that the armed hostilities went beyond isolated or sporadic acts. During the charged period, there was also no peaceful settlement. That is, there was no lasting cessation of armed confrontations between the parties without the real risk of resumption of hostilities. Witnesses described the armed conflict before and during the charged period and the sufficient organization of the groups that sustained it. They described military campaigns that were coordinated through identifiable command structures. I refer Your Honors to the evidence of prosecution witnesses P370, P706, P337, P764, P767, and P1059, detailed at paragraphs 24 to 35 of our brief. The armed groups participating in the conflict included the Libyan National Army, or LNA, under General Haftar, forces affiliated with the GNA, and armed groups in Tripoli, Zintan, Tarhuna, Misrata, and other areas across Libya. I will briefly set out some of the evidence showing that since 2011, Libya has experienced recurring and overlapping phases of armed conflict involving organized armed groups, militias, security forces, and rival governing authorities. Starting in 2011, the UN Security Council expressed concern of the proliferation of arms in Libya and its potential impact on international peace and security. Acting under Chapter 7 of the Charter of the United Nations, the Security Council passed numerous resolutions, including to establish UNCIMIL and UN fact-finding mechanisms, and it renewed their mandates over the years. Thereafter, the UN Security Council remained consistently seized of the situation in Libya until today. The existence of a non-international armed conflict in Libya during the charged period, or the facts through which the Chamber can conclude that such armed conflict existed, has been recognized repeatedly by the United Nations Security Council, by UNCIMIL, by international investigative bodies such as the Panel of Experts and the Fact-Finding Mission in Libya, and by NGOs, researchers, and academics. These reports are in evidence. The non-international armed conflict in Libya that began in 2011 was between state and non-state actors. The subsequent developments that I will briefly rehearse demonstrate the continuity of armed hostilities and the consolidation of armed groups that later operated during the charged period. In March 2012, UNCIMIL reported that intermittent clashes posed a challenge to authorities because of the continued proliferation of weapons on the streets and the large number of armed brigades. Researchers reported that, I quote, across the country, the number of armed groups exploded in the chaos that ensued after the Gaddafi regime's demise, end of quote. In 2013, the UN Panel of Experts reported that fighting continued between government forces and former Gaddafi-aligned regions. With the launch of Operation Dignity in May 2014 by the LNA, OHCHR reported that, quote, 2014 saw the most serious emergence of hostilities since 2011, end quote. This was followed by a retaliation in July 2014 by the Libya Dawn Alliance, composed of armed groups from Misrata and Tripoli. Together, the Libya Dawn Alliance conducted coordinated military operations, including airstrikes and shelling of urban areas, clear indicators of the required intensity. OHCHR reported that these clashes continued into 2015. They were not isolated incidents, but formed part of sustained, high-intensity armed confrontations. UNCIMIL further reported about repeated attacks on Mitiga International Airport between September 2014 and February 2015, demonstrating the strategic nature of the hostilities. In August 2015, the SRSG reported to the UN Security Council on the protracted nature of the violence, describing the situation 15 months later as, quote, a war of trenches with no imminent end foreseen, end quote. UNCIMIL reported clashes and fatalities in Tripoli in December 2016 and into 2017, with a number of additional deaths and the takeover of a number of ministerial facilities, including the Ministry of Defense. In early 2018, UNCIMIL reported an escalation in clashes between SDF Rada and the Al Bugra militia, and I will spell it for the record. A-L space B-U-G-R-A. That had launched a major assault on Mitiga Airport, resulting in at least 23 deaths and 60 injured persons. Fighting in Tripoli between Tripoli-based armed groups and armed groups from Tarhuna and Misrata was reported by UNSMIL in August 2018, resulting in the death of at least 120 civilians and the closure of the Mitiga International Airport for several weeks. On 4 April 2019, the LNA launched an offensive to seize control of Tripoli. The UN panel of experts described it as the onset of nationwide conflict between the LNA and the GNA, each backed by other armed forces. Witnesses state that SDF Rada fought in this war against General Haftar's LNA forces. In 2019 alone, UNSMIL reported nearly 650 civilian casualties and over 300,000 internally displaced persons. UNSMIL reported that since the onset of the conflict in 2019, ground fighting continued in and around Tripoli. The LNA had conducted some 850 precision airstrikes by drones and 170 strikes by fighter bombers. And the GNA and affiliated forces conducted some 250 airstrikes. According to UNSMIL, the Mitiga International Airport was repeatedly targeted in the second half of 2019, including by LNA air and ground forces. UNSMIL reported that by April 2020, there had been 850 breaches of a truce that had been temporarily accepted by the GNA and the LNA 3 months earlier. This demonstrates the lack of a peaceful settlement. The risk of resumption of hostilities was ever present. Your Honors, I will now turn to the evidence showing the nexus between the crimes and the armed conflict. As the ICC Appeals Chamber in Ntaganda has emphasized, the existence of the nexus between the crimes and the conflict is fact-sensitive and draws on multiple factors. The conflict does not need to be the sole motive or even the predominant motive to prove the nexus to the commission of war crimes. The relevant question is whether the armed conflict substantially enabled, shaped, influenced, or facilitated the commission of the crimes. Some crimes may possess mixed or opportunistic motives and nonetheless remain sufficiently connected to the armed conflict. In the assessment of nexus, the Kunarach Appeals Chamber at the ICTY held that the existence of the armed conflict must have played a substantial part in the perpetrator's ability to commit the crime, his decision to commit it, the manner in which it was committed, or the purpose for which it was committed. And in the appeals judgment in Tadich, the Chamber held that offenses committed in detention facilities controlled by armed actors may satisfy the nexus requirement even where personal motives coexist with conflict-related objectives. Accordingly, detainees who are arrested for reasons other than formal affiliation with opposing forces may still be victims of war crimes. Persons arrested and detained at Mitiga Prison and compound were targeted for a range of purported reasons. The fact that some detainees were targeted for extortion, perceived moral transgressions, religious nonconformity, or personal vulnerability does not sever the nexus to the armed conflict. Article 8 of the Rome Statute contains no express limitation that only persons detained for reasons related to the conflict can be victims of war crimes. To the contrary, appeals chambers in the Kunarach and Afghanistan cases establish that the armed conflict need not be the reason for the detention, and that it is sufficient that the conflict provided the perpetrator with the opportunity, position, or means to commit the crimes. Without the armed conflict, Khaled al-Hishri and his associates could not have possessed the means, structures, or authority through which these crimes were perpetrated. The armed conflict in Libya substantially enabled every stage of the criminal conduct. The arrests, the operation of the Mitiga prison complex, the authority of the perpetrators, the climate of impunity, and the sustained abuse inflicted upon detainees. Not only did the conflict enable the crimes by facilitating SDF RADA's control of Mitiga prison, but also some victims were in fact detained for reasons associated with the conflict. Some of the perpetrators were associated with one party to the conflict. Some victims were associated with a party to the conflict as well. Some crimes were carried out to further the conflict by generating funds, extracting information, and using enslaved persons. There are, we submit, substantial grounds to believe that the nexus requirement under Article 8 is satisfied. The crimes were not isolated acts of ordinary criminality detached from the hostilities. Your Honors, turning briefly to Khaled al-Hishri's awareness of the factual circumstances of the armed conflict. The armed conflict was not distant or abstract. It surrounded the Mitiga compound and prison on a daily basis through visible armed checkpoints, clashes, military deployments, and shifting front lines throughout the city. Witness P-1041 described SDF RADA's depot of heavy weaponry and ammunition on Mitiga compound. He described that detainees, including Black African migrants, were forced to take part in hostilities. Other witnesses state that Khaled al-Hishri participated in battles at the prison in 2015 when Mitiga was attacked by another armed force, and that RADA participated in fighting at other times, including in 2019 and 2020. Khaled al-Hishri himself and other Mitiga leaders and perpetrators under his authority routinely and openly referenced the ongoing conflict during interrogations and abuse, as described by witnesses P-1073 and P-1673. The evidence, Your Honors, establishes that Khaled al-Hishri was aware of the factual circumstances of the armed conflict. Madam President, Your Honors, this concludes my presentation. After the break, Mr. van der Werf will present the evidence establishing the crimes listed in counts 1 to 12. Thank you.
Merci beaucoup.
Thank you very much for your presentation. We will now break and resume at 15:15, says the judge.